Welcome to the deep dive session that plunges into the legal context in setting up a business in Sri Lanka, presented by Ms. Ayomi Aluvihara, the Precedent Partner at FJ&G Diserum. Ayomi, over to you.
Greetings. Legal context in setting up a business in Sri Lanka is the present topic. I will discuss foreign investment and the setting up of business in Sri Lanka in light of the questions that have been raised by business and the responses that have been given. Moving on to the presentation. The legal system of Sri Lanka has been influenced by two key legal systems, and that is the Roman Dutch law and the English law. It is a distinct culture of a mixed legal system, the Roman Dutch law on the one hand and the English law on the other hand. Personal laws do apply in certain instances, but from the point of view of commerce and business, what is largely applicable is the English law. English law was introduced by the Civil Law Ordinance of 1852, by which the English law was made applicable to all commercial and maritime matters. The English law today applies to partnership, principals and agents, life and fire insurance, corporations, banking, and trust. Today, many of the laws are in statute, and that is something we will see as we go through this presentation. The Roman Dutch law is the common law of the country and applies to, importantly, the law of contract and to land. Is foreign investment protected? The bilateral investment treaties that Sri Lanka has entered into with 29 countries has the force of law. And it has the force of law by virtue of provisions in the Constitution. The bilateral investment treaties also give a constitutional guarantee that no legislative, executive, or administrative measures will be taken in contravention of any provision of the treaty. The bilateral investment treaties are largely uniform in scope and content, and contain provision for fair and equitable treatment, that is, a fair treatment of foreign investment, a favorable environment for foreign investment, national treatment, which is equal treatment to investment of foreign investors as accorded to investment of nationals, guarantee against unlawful expropriation, that is, expropriation, nationalization, and confiscation only in terms of the law and only against adequate compensation, and of course, importantly, the ability to repatriate both capital invested as well as returns. Sri Lanka is a member of the International Center for Settlement of Investment Disputes Convention, and as such, all the bilateral investment treaties provide for settlement of disputes between an investor and the Sri Lankan state by ICSID arbitration. Sri Lanka is also a member of the Multilateral Investment Guarantee Agency, a World Bank organ that encourages investment. The Multilateral Investment Guarantee Agency Act sets out the obligations of Sri Lanka as a member, and in terms of what MIGA offers, in terms of the encouragement of investment and the services offered, economic and political risk insurance is one measure available. Is foreign investment possible in all areas of business? The liberalization of the economy in the 80s saw a change which allowed foreign investment. Foreign investment today is as set out and as permitted by the Foreign Exchange Act and is possible in most areas of business. Foreign investment, in other words, is possible in voting and non-voting shares in mostly all areas of business. The restrictions are what appears on the slide. Investment in voting shares is prohibited in the areas included in the circle. So pawnbroking. Foreign investment is possible in non-voting shares, but not in voting shares. Foreign investment is restricted up to 40% in voting shares in the areas depicted in the middle shape. So for example, shipping agency investment is allowed only up to 40%, or as approved by the Board of Investment of Sri Lanka for a higher percentage. Investment is possible in voting shares in the areas in the last shape only where the relevant administrative body approves investment up to a certain percentage. Investment in shares are subject to the condition only that the investment must flow through an inward investment account opened by an investor in a licensed commercial bank in Sri Lanka. Investment is also possible in debt securities as well as financing. The terms applicable to debt investment differ slightly depending on the borrower. For example, debt securities issued by a company or financing to a company is possible subject to a minimum term of 3 years. This is not applicable to borrowings by or debt instruments issued by banks or other financial institutions. Once foreign investment has flown into the country, foreigner invests in a company, for example, that company is subject to the foreign exchange laws, and as such, capital transactions are possible only to the extent permitted. Current transactions are permitted. So international trade, payments for international trade, which is a current transaction, is permitted. In terms of the facilitation regimes, and that is something I will talk about a little later, it is possible for a business to be entitled to or have a right to or be granted an exemption from the application of the foreign exchange law. Legal entities for business. Typically, a business is a company or a branch of a company set out outside Sri Lanka. The Companies Act provides for both these forms of business entities in Sri Lanka. A frequently asked question is, should I invest through a company or should I invest through a branch? There are pros and cons on each. A company is an entity with a separate, distinct legal personality in Sri Lanka, and as such, liability will be ring-fenced to that entity. A branch is only a branch with no separate legal personality, and the entity that would incur liability and incur obligations is the overseas company registered in Sri Lanka. Also, from a foreign exchange control point of view, or foreign exchange point of view, the types of business a branch can carry on in Sri Lanka is limited when compared to the types of business that a company a company with foreign investment can carry out in Sri Lanka. That being said, there are many big foreign businesses that have branches in Sri Lanka. An example are all of the foreign banks. A third entity is the offshore company, a company that proposes to carry on business outside of Sri Lanka may register itself as a separate entity under the Companies Act and engage in business that is from Sri Lanka with parties outside Sri Lanka. Any business seeking to carry on business or engage in business in the Colombo Port City Act must be registered as an offshore company. The structure of a company is something familiar because our company's law is English law based. The Articles of Association contain the internal governance provisions of a company. The share capital, there is no minimum investment requirements at present. Shareholders can be one, subject to sector requirements and sector legal requirements. The minimum shareholding is one. A company, the business and the business affairs of a company is managed by the board of directors of the company. And in terms of the Companies Act, the minimum number of directors is again one. And a director may be resident in Sri Lanka or outside Sri Lanka. The number of director criteria sometimes is imposed by sector-specific legislation. The Companies Act is administered by the Department of Register of Companies, the Registrar General of Companies being its head. The EROC platform managed by the Department of the Register of Companies means that all filings presently are possible online. I have listed out some laws that are relevant to business in Sri Lanka. This is by no means exhaustive. The purpose of listing the applicable laws was to demonstrate really that many of the laws are statutory. Just to touch on a few, the investment facilitation laws of the Board of Investment of Sri Lanka law, the Strategic Development Projects Acts, and the recent Colombo Port City Economic Commission Act. Investment facilitation is provided by one-stop or single window facilitation, by the grant of incentives, exemptions, and concessions, by facilitation of visa and assistance that range from environmental approvals to many other services. The e-commerce facilitation, the digital Sri Lanka endeavor has seen a multiple number of laws come into being. The Electronic Transactions Act in this COVID time has enabled business to continue by the legal recognition and validity given to e-documents and e-communications. Electronic signatures are recognized, and this has facilitated, as I said earlier, the e-commerce endeavors particularly in this last year. We have a draft data protection bill and a draft cybersecurity bill, which we expect to pass into law soon. A question that is raised frequently is on whether a contract can be governed by a law other than the law of Sri Lanka. The courts in Sri Lanka have recognized the application of rules of private international law, and as such, parties to a contract may choose a law other than the Sri Lanka law to govern their contract, and it is not infrequent to have the English law govern contracts, particularly contracts dealing with companies and shares, as well as contracts relating to financing, lending, and borrowing. Sri Lanka has entered into 38 double taxation treaties. Lastly, I would like to touch on dispute resolution, again, a frequently discussed topic, particularly amongst lawyers from outside Sri Lanka and ourselves. Sri Lanka is a party to the New York Convention, the UN Convention on the Recognition of Enforcement of Foreign Arbitral Awards. It is also a member of the UN Convention of International Settlement Agreements resulting from mediation. The New York Convention provisions have been given effect to by the Arbitration Act number 11 of 1995, which is based on the UNCITRAL model law, which recognizes both ad hoc as well as institutionalized arbitration. The ADR Center of the Ceylon Chamber of Commerce and the Institute for the Development of Commercial Law and Practice has 25 years. It is a successor to an arbitration center set up by the ICLP and has 25 years of experience in commercial arbitration. The International Commercial Dispute Resolution Center is to be set up in the port city for resolution of disputes between the Commission and those engaging business within the port city. This said, it is not infrequent to have and to see parties agree to arbitration proceedings that are subject to a center, an institution outside of Sri Lanka. SIAC, the Singapore International Arbitration Center, the ICC, the Hong Kong Center are all centers that we see parties use as a dispute resolution mechanism. In the last year, we have seen in Sri Lanka hybrid and fully virtual arbitrations conducted under the SIAC rules, under the ICC rules, quite successfully, with parties sitting partially in Sri Lanka, partially in Singapore, and in at least 3 other countries, enabling the continuation of proceedings notwithstanding the last year. Though arbitration is a preferred means of dispute resolution for foreign investors, courts provide necessary support for urgent relief, for judicial review of administrative action, and the enforcement of arbitral awards. I've come to the end of my presentation. I will just see whether there are any questions. There is one question, I will read it. Is D&O insurance available in Sri Lanka for board members? And the answer is yes. The Companies Act recognizes that and contains provision for companies to bear the cost of insurance, and it is frequent for directors to obtain or for companies to obtain D&O insurance for its directors. It is a product offered by the insurers in Sri Lanka. Thank you very much.